All right, good afternoon. I'm Dean Jessica Berg, and I'd like to welcome you to our annual Sumner Canary Lecture. This is one of our law school's premier endowed lecture series, which brings extraordinary jurists to the school to discuss current legal issues. The lecture series was established to honor the memory of the late Judge Sumner Canary, a judge on the Ohio Court of Appeals for the 8th District, U.S. Attorney for the Northern District of Ohio, and 1927 graduate of this law school. It is made possible through the generosity of his widow, Nancy Halliday Canary, who has joined us here today. Thank you so much for doing this. We are very honored today to have the Honorable Joan R. Larsen, a judge on the United States Court of Appeals for the 6th Circuit, as the 2018 Canary Lecturer, and one of our most distinguished, cited, and well-known chaired professors, Jonathan Adler, who's the director of the Center for Business Law and Regulation and the organizer of this event, will tell you a bit more about the judge in his introduction. So, Jonathan.
Thank you, Jessica. It's certainly my pleasure and an honor to be here this afternoon to introduce the Honorable Joan Larsen. I will be very brief because none of you are here to listen to me, but it's a real pleasure to have Joan Larsen here to speak because of her distinguished career, beginning first in her class at Northwestern Law School, and where afterwards clerked for Judge David Santel on the U.S. Court of Appeals for the D.C. Circuit, and then for the late Antonin Scalia. She worked in private practice in Sidley and Austin, served in the Office of Legal Counsel at the Department of Justice, has taught at Northwestern as well as at the University of Michigan, where she received the L. Hart Wright Award for Excellence in Teaching. And before her current position, was initially appointed to be a justice on the Michigan Supreme Court and then ran for re-election to retain her seat before last year when she was nominated by the president to her current seat on the U.S. Court of Appeals for the 6th Circuit. And if I recall correctly, she received 60 votes in favor of her confirmation, which these days is actually quite a lot, which in all seriousness, I think speaks to the respect and recognition her work has received these days. As we know, votes on judicial nominations, especially to appellate courts, are typically along party lines. Not only did a significant number of senators cross party lines to vote for her, but if one looks at the letters in support of her from her colleagues at the University of Michigan, relatively few of which I'm quite sure were supporters of the president in the last election, as well as the remarks of others about her work as a scholar, her work as a member of the legal community, the concerns she's had about the administration of justice, you understand why we were so pleased when she accepted her invitation to come here. On a somewhat personal note, I'm also pleased that she's here because in her time on the Michigan Supreme Court, she wrote a concurring opinion in a case which may not sound to be of great importance, but dealt with the very important question of whether or not a driveway is generally accessible to motor vehicles. And unlike, and this is my comment, not hers, unlike most of her colleagues on the court, she felt that to ask the question was in many respects to answer it, and I look forward to teaching that case in my legislation and regulation course where we focus on statutory interpretation for many years to come. But really, with no further ado, let me turn it over to the Honorable Joan Larsen. It's certainly my pleasure to welcome her here and introduce her to all of you. Thank you.
So, good afternoon. It is a great pleasure to be here with all of you. This is actually my first time stopping in Cleveland. My in-laws live in a tiny little town between Erie and Buffalo, and to get there from Michigan, we drive through Cleveland, but we have never had the occasion to stop. And so I am very glad to see what a lovely city this is. I saw that the botanical gardens are close by and the art museum, and I'm hoping I'm going to have a chance to take advantage of them tomorrow before I go back up north. So thank you, Professor Adler, for your introduction. I want to thank the Case Western University School of Law for hosting this event, and particularly I want to thank Nancy Canary, the widow of Judge Canary for endowing this lecture. And also thanks to all of you for being here today. As Professor Adler mentioned, this lecture was established to honor the memory of Judge Sumner Canary, and he spent a good deal of his time in the state court system and was also U.S. attorney, so spent some time in the federal system. I have something in common with Judge Canary in that I too have served in both systems. I currently serve on the U.S. Court of Appeals for the Sixth Circuit, but before that, I had the honor of being a justice on the Michigan Supreme Court. And that's what I want to talk to you about today. Recent years have witnessed a renewed interest in state courts and their relationship to their federal counterparts. For example, my colleague on the Sixth Circuit, Judge Jeff Sutton, has recently published an excellent book on state constitutional law entitled 51 Imperfect Solutions, States and the Making of American Constitutional Law. I just learned today that he will be here later this academic year to discuss the book. And it is an excellent book, and I am going to talk about it a little bit in my remarks today. But I will also offer a bit of a dissent in advance. So when Judge Sutton comes here, you can ask him what he thinks about my dissent. So his book, which I will discuss a little bit later on, argues that state courts play a critical, though underappreciated role in our national judicial system. So with those things in mind, I'd like to talk to you about some of my perspectives on the relationship between state courts and federal courts. I thought I would first tell you a bit about my transition from the state bench to the federal bench and some things I noticed right away. Next, I'd like to comment on the importance of state courts in our federal system and the important ways in which they can operate to improve justice in America. I'll also offer a few thoughts about their limits. And lastly, I'll wrap up with some ideas about how my experience as a state court judge has influenced the way I do my current job as a federal appellate judge. So first, let me talk about my transition from state court to federal court. I'm often asked, what are the differences between serving as a justice on a state's highest court and serving in the federal system as a mere intermediate appellate court judge? Before I begin, I should say that, of course, I can only speak of my own experience, and someone who served on a different court, the Ohio Supreme Court or any other Supreme Court, might have a different view. But from my experience, I noticed three things right away. The first thing I noticed is that it is an election year, and I am not on the ballot. In Michigan, as in Ohio, we elect our judges, although the governor holds the power to appoint judges to fill a vacancy that arises in between elections. And that was my situation. I was appointed to the Michigan Supreme Court in the fall of 2015 to fill a vacancy. But under the Michigan Constitution, a judge appointed to fill a vacancy must stand in the next statewide general election. So for me, that election was in the fall of 2016, and I am delighted to say that I won my first and last election for public office. So for starters, how one gets a seat on a state court as opposed to a federal court can be different. Almost half the states use some form of election to select their high court justices. And obviously, the federal selection process of presidential nomination and Senate confirmation is quite different. I obviously cannot comment on current controversies, and so I will not dwell long on this topic. I will pause long enough only to note two things. The first is that there must be some form of democratic input in the process of selecting our least majoritarian branch of government. And second, there will always likely be disagreement about what form that democratic input should take, whether that be election or appointment, and within those broad categories, just precisely what the details ought to be. Contested elections, retention elections, confirmation processes, and the like. There is no perfect solution to the problem of selecting who will sit in judgment of our laws, our leaders, and ourselves. We can only ask that the process be transparent and that the process be fair. So having been appointed and confirmed through the federal system, one of the first things I noticed when I arrived at the Federal Court of Appeals is that my colleagues are really far away and they change all the time. The Sixth Circuit, which comprises Tennessee, Kentucky, Ohio, and Michigan, is geographically dispersed, by which I mean that we have our chambers in our home states and in different cities within those states, and then we come together only to hear oral argument in Cincinnati. And when we go to Cincinnati, we sit in rotating, random, 3-judge panels. So the first of these features, geographic dispersion, is not a feature of all federal appellate courts. The DC and federal circuits are notable exceptions, but it is a feature of most of them, and it affects the way that the court operates more than I had anticipated. Before I came to the Sixth Circuit, I had had some form of appellate experience in 3 courts. I had been a law clerk on the DC Circuit, a law clerk on the US Supreme Court, and then a justice of the Michigan Supreme Court. And what all those courts have in common is proximity. The judges and the law clerks are regularly in one building. Some say that familiarity breeds contempt, but that was not my experience. I found it incredibly useful as a law clerk to be able to walk down the halls and puzzle through a tricky legal question with clerks from other chambers who are working on the same case. Our work was hard and we were fresh out of law school, and having the benefit of those different perspectives helped me help my judge. And that was made easier because we were physically together. As a justice of the Michigan Supreme Court, I found this equally true. My work was made better by the chance to discuss hard problems with my colleagues, face-to-face and one-on-one. So before I arrived at the Sixth Circuit, I was concerned that the distance might hamper the judge's ability to have meaningful discussions about legal topics. But I have been pleasantly surprised by the willingness of my colleagues to engage in discussion of cases. Although I'm new to the court, my colleagues have been very welcoming and we seem to get along quite well. But our distance from one another does present challenges. It means that we have to make more of an effort to keep those lines of communication open. We can't discuss a case in the hallway, over coffee, over lunch, because we're not together. And so our communication needs to take often a more formal tone. We exchange memos, we write emails, and we pick up the phone. But there's a little barrier there. You can't just walk down the hall. You have to think more precisely about what you're going to say. I can't decide whether that's a benefit or a detriment. Obviously, it is always good to think carefully about what you're going to say next. And having to pick up the phone or write an email or send a memo obviously produces that result. But on the other hand, those casual one-on-one interactions often gave me some of my best ideas. There's not much we can do about geographic dispersion. It is a feature of appellate courts that that cross state lines. But it does ultimately have the benefit of bringing together a group of judges with diverse backgrounds that reflect the legal communities in which they practice. A different but related way in which federal courts of appeal differ from their state counterparts is that the panels by design are constantly changing. When we go to Cincinnati to hear argument, we typically hear argument over 4 days. And in the course of those 4 days, we will sit on 2 different panels. That means that in any given court week, I will sit with 4 different judges, and the next month it will be a different 4, and so on. The process of drawing judges is random, so sometimes there are repeat players, which means that it may take months or even years before I will actually have served on a panel with all of my judicial colleagues. By contrast, state Supreme Courts and the US Supreme Court always sit en banc. And what that means as a judge is that you quickly get to know your colleagues, both as jurists and as people. And that facilitates the exchange of ideas, not only in the informal way occasioned by proximity that I just discussed, but also in the sense that when you sit together repeatedly, you learn what to expect. Different judges have different styles for argument and opinion writing. Some judges, for example, always like to ask the first question, and others the last. And figuring out just how to insert oneself into the argument and how to adapt one's own style to facilitate conversation is just easier in a court that convenes with the same 5, 7, or 9 actors every time. The last thing I noticed instantly upon arriving at the Sixth Circuit is the difference in the docket. In federal appellate courts, appeal is by right, and that means that our court resolves every case that is presented to us, from the most jurisprudentially significant cases that will establish precedent for years to come, to cases in which the law is largely settled, and so the dispute, while incredibly important to the parties before the court, will not likely make any mark on the lasting fabric of the law. By contrast, on state and the federal Supreme Court, appeals are by leave only. And so the judges not only have to decide the cases before them, they also have to decide what to decide. And that work occupied a great deal of our time. As with any court that has a discretionary docket, broader decisions come into play when deciding what cases to hear. We would think about things like whether the legal question at issue was unsettled in our state, whether we could clarify an area of the law that had caused problems throughout the state, whether new legislation might have affected some of our old rulings. But put simply, the state Supreme Court could not fix every error that came our way. We had to focus on cases that presented broader issues that would affect the state as a whole. As a result, the cases we actually heard on the state Supreme Court almost always presented a legal puzzle. If we had decided to hear the case, it was generally because something about the law was in need of correction or clarification. On the Sixth Circuit, we also get cases that are legally challenging, plenty of them. But we also hear cases that present no legal mysteries. These cases might not be legally challenging, but they are nonetheless hard in that they involve the painstaking work of reading through a record to make sure the district court or the agency or whoever the decision maker was below got the case right, that they appropriately applied the facts to a legal regime that is largely settled. These are not always the most glamorous cases, but to the people and to the entities involved, they are just as important. It matters a lot in the real world to the claimant and to the taxpayer, whether, for example, Mrs. Smith was appropriately or wrongfully denied disability benefits. And it matters a lot in the real world to the defendant, to law enforcement, and to the citizenry, whether there was probable cause to support Mr. Jones's arrest. And so on the federal appellate court, it is our job to fix every error. That is a different role, and it is not one that is less important than the role of a state's high court. So these two roles are different, but the federal courts seem to have captured more of the public's imagination than their state counterparts. And of course, as I said, what we do matters a great deal. Because the U.S. Supreme Court hears so few cases, federal courts of appeal are truly the courts of last resort for most federal litigants. But I am not sure that many people appreciate the significance of state Supreme Courts. These courts not only shape and form the common law, but they also bear the truly tremendous responsibility of having the final say on interpretation of state statutes and state constitutions. And it is this work that I will discuss next. So why does the day-to-day work of state courts matter? It seems like most media coverage is of the federal courts, and in particular of the U.S. Supreme Court. Why should we pay attention to the work of state courts? Well, the first reason is that state courts directly affect people's lives. Judge Sutton noticed in his recent book that by one count, 95% of the disputes resolved by courts in this country are filed in the state courts as opposed to the federal. And that makes sense, because the kinds of disputes that ordinary people might have with one another sound in tort, contract, and real property, quintessential state law topics. And most criminal law and nearly all family law are still the province of the states. To the extent that these subjects are common law subjects, the state courts will be the law developers, even if the cases end up being tried in federal court. And to the extent that legislatures have a hand in these areas, state legislatures, not Congress, are still the dominant players, the expansion of the Commerce Clause notwithstanding. And state courts, of course, have the final say on the interpretation of state legislative acts. So just in terms of sheer volume, state courts are where the action lies. Judge Sutton's new book, to which I alluded earlier, points out another way in which state courts matter. They can be innovators, or as I like to think of it, dissenters from the federal regime. This is true in a couple of ways. One is that often state law need not conform to federal law. Judge Sutton focuses his attention on state constitutional law, and I will say a few words about that. But there are myriad other ways in which state courts need not follow in lockstep with their federal brethren, even when confronting similar problems. State courts can thus dissent from the federal model and perhaps provide useful experience to inform a larger discussion. One example that comes to mind is Chevron deference. Of course, the underlying dispute over Chevron deference is whether and how much it is appropriate for the judiciary to defer to an administrative agency's interpretation of the law, and whether giving such deference impermissibly divests the judiciary of judicial power. Much has been said recently on this topic, and I am not here to enter the fray, but I do note that it is an area in which state courts, many state courts, have gone another way, and that includes Michigan. In a case called In Re Complaint of Robas, the Michigan Supreme Court held that agency interpretations of statutes were entitled to respectful consideration, but that courts still retained primary responsibility for interpreting statutes according to their plain language. As a result, Michigan courts are untethered from an administrative agency's interpretation of a statute and instead conduct de novo review of the statutory interpretation questions presented to them. And in a very recent decision of the Ohio Supreme Court, the justices suggested that Ohio's High Court likewise is interested in the question whether state agencies should be given Chevron-type deference for their interpretations of the law. Again, the point is not to praise or condemn Chevron deference. Instead, my point here is that there are all sorts of ways in which state courts can accept, reject, or tinker with federal doctrines. And this might provide data to and inform a larger national discussion about important legal topics. As I mentioned at the outset, there has been a renewed interest of late in the states as laboratories of constitutional law. Judge Sutton's book on this topic, 51 Imperfect Solutions, is an excellent look at the history of state constitutional law and offers a superb discussion of some of the events that have kept state courts from developing state constitutional law. The book also offers some intriguing ideas about what courts and litigants might do going forward to give state constitutional law its own meaning, distinct from the federal Constitution. And I can't think of a better author for such a book than Judge Sutton, who has served over 15 years on a federal appellate court and who previously served as the State Solicitor General of Ohio. His experience, both as a federal litigator and a Supreme Court clerk, but a federal court judge, makes him eminently qualified to speak on this topic. For those who haven't had an opportunity to read the book, it's an in-depth exploration of the role of state constitutional law in our nation's constitutional history. He discusses how states have set both negative and positive examples that have affected the development of our constitutional law. And the book does this by exploring 4 specific areas: school funding, the exclusionary rule, compelled sterilization, and mandatory flag salutes. It then offers some thoughts about how state constitutional law can be taken more seriously, focusing on what judges, attorneys, state bars, and law schools can do to give state constitutional law a more prominent voice in the discussion of individual constitutional rights. Judge Sutton believes that an underappreciation of state constitutional law has hurt state and federal law and has undermined the appropriate balance between state and federal courts in protecting individual liberty. Judge Sutton raises many thought-provoking points, too many to address in this lecture. But I thought I would share a few thoughts in response to some of his ideas about the future of state constitutional law. The book is in large part a quest to figure out why state constitutions don't receive as much attention as their federal counterpart, and what can be done to correct that, to encourage litigators to include the state constitutions as part of their litigation strategy, and perhaps as a source of rights protection for individuals. Early on in his book, Judge Sutton states that if the reader has doubts about whether state constitutions have taken a back seat to the federal constitution, he should, quote, ask a state court judge about the frequency with which claimants raise federal and state constitutional challenges to state or local laws, and the seriousness with which they raise the state claims, if they raise them at all. So I am that judge. During my time on the Michigan Supreme Court, arguments that the Michigan Constitution protected different rights or protected the same rights differently than the United States Constitution did were few and far between. On the rare occasions in which they were raised, they usually amounted to little more than throwaway arguments. Counsel might end a brief or an argument by saying, in conclusion, if you find that the federal Constitution does not require this, then you should find that the state constitution does. End of argument. This might be somewhat surprising, as the Michigan Supreme Court has a history of showing some willingness to rule solely under its own state constitution. The most well-known example is a case called Sitz versus the Department of State Police. There, the Michigan Court of Appeals had held that sobriety checkpoints violated the Fourth Amendment. That is, the Fourth Amendment to the U.S. Constitution. And the Michigan Supreme Court denied leave, which meant that it left that intermediate appellate court ruling in place. The United States Supreme Court then granted certiorari, reversed, and held that the checkpoints did not violate the Fourth Amendment to the U.S. Constitution. Undeterred, on remand, the Michigan Court of Appeals, in a somewhat bold move for an intermediate appellate court, held that although sobriety checkpoints may have been permitted by the United States Constitution, they nevertheless violated the analogous search and seizure prohibition in the Michigan Constitution. And the Michigan Supreme Court later affirmed that decision. This is not the only occasion in which the Michigan Supreme Court has held that its state constitution provided broader protection than its federal counterpart. In a case called County of Wayne versus Hathcock, the Michigan Supreme Court addressed a question that would come before the U.S. Supreme Court the very next year. The U.S. Supreme Court case, with which many of you may be familiar, was Kelo versus City of New London. In that case, the United States Supreme Court held that the Takings Clause of the United States Constitution did not prohibit a state from using its power of eminent domain to take private property from one individual and give it to another pursuant to an economic redevelopment plan. The redevelopment plan in that case was to take individuals' homes in an area of the city that the court deemed blighted in order to allow other private individuals to put the land to commercial, residential, and recreational uses that would perhaps revitalize the area. The U.S. Supreme Court held that such economic redevelopment plans constituted a, quote, public use for purposes of the Takings Clause. Just 1 year earlier, the Michigan Supreme Court had confronted the same issue under its own constitution and had come to the opposite conclusion. condemning private homes in order to allow other private entities to build a large business and technology park with a conference center, hotel accommodations, and a recreational facility was not, according to the Michigan Supreme Court, a, quote, public use. The U.S. Supreme Court took note of Michigan's Hathcock decision when it decided Kelo the following year, but was not persuaded. It did, however, emphasize the role that state constitutions could play in providing greater protections for the property rights of its citizens. Yet despite the apparent willingness on the part of the Michigan Supreme Court to consider arguments that its state constitutional provisions provided more or different protections than their federal counterparts, meaningful arguments to that effect were nearly non-existent during my time on that court. And as Judge Sutton states, failing to argue for rights protection on both state and federal constitutional grounds may be a serious disservice to one's client, who is potentially missing out on an avenue to victory. But I also want to dissent a little bit from an implicit charge that might flow from this exploration of the possibilities of state constitutional law. That is the charge that state Supreme Court justices, as a whole, may not have done enough in the way of what Judge Sutton calls rights innovation. And here I should make clear that Judge Sutton himself does not levy this charge or take a position on this topic. To introduce this idea, I should state what you likely already know, that state constitutions can only grant rights more generous than those protected by the federal Constitution. Since the late 1960s, when the Supreme Court had largely completed the task of incorporating most of the Bill of Rights against the states, federal rights guarantees have preempted any less generous state constitutional analog. So any work for state constitutions must consist of granting protections where the federal Constitution might fall short. That is likely why Judge Sutton refers to state constitutions and their state judicial interpreters as having the potential to be, quote, rights innovators. But even presuming that there are areas in which the federal Constitution could use some help, it is not clear to me that it is necessarily appropriate for state judiciaries, as opposed to other institutions, to be the primary innovators. Certainly, judges must take seriously any state constitutional challenge that is brought before the court, and must consider the real possibility that their state charters might grant broader protections than are afforded by existing interpretations of the federal and state constitutions. But at the other extreme, I don't believe Judge Sutton to be advocating that state judges invent more extensive rights from thin air. And so that puts front and center the interpretive question. To make the question a little more concrete, I asked myself, if, when I was a justice on the Michigan Supreme Court, someone had brought us a case asking us to find a state constitutional protection broader than the federal right, what tools would I have used to figure out whether that litigant was entitled to that protection? What legal sources would I have looked to? If we want judges to employ the traditional tools of constitutional interpretation, the big three being text, history, and precedent, then we have to ask ourselves, first, how available these sources will be as they pertain exclusively to state constitutional law, and second, how likely they will be to yield an answer that is both different than and more generous than the analogous federal constitutional right. Now, sometimes, of course, the text will just be different. There are written provisions in many state constitutions that have no federal analog. Some state constitutions, for example, contain things called single subject rules. Some grant affirmative rights that are not guaranteed by the federal Constitution, rights to education being a prominent example. But often, state rights mirror federal rights. Or actually, in older states, it's the other way around, since most federal Bill of Rights protections were modeled on the rights protected in the pre-existing state constitutions. So if, as a state judge, you are faced with a text that replicates or closely tracks the federal constitutional right, what are the chances that it means something different, or that it meant something different as originally understood? Now, it might, of course, but if we are talking about a cognate provision, particularly one worded nearly identically or using a legal term of art, there is probably a decent argument that when the federal Constitution borrowed the phrase from the state Constitution, or vice versa, the borrowing Constitution meant for the provision to have the meaning that it had in the original document. That's likely why it borrowed it instead of saying something different. And if that's right, we would not expect to see divergence in state and federal constitutional meaning. Of course, it could be that the provisions shared the same original meaning, but the judges of one court or another later strayed from that meaning. And if the federal judges were the ones to stray, then we might see room for state courts to correct the error. But of course, state courts can only correct errors that fall in one direction. They can only be more generous than the federal constitutional right. And here, I'm just a little skeptical that there are many state constitutional rights that are being under-enforced relative to both the original meaning and to the interpretation given to their federal cognates. And that is because, as Judge Sutton explains in his book, it was the state's relative under-protection of individual rights that led the Supreme Court to incorporate the Federal Bill of Rights against the states in the first place. There will, of course, be exceptions. The examples of the Hathcock and Kelo cases I just mentioned is a good one. There, the Michigan Supreme Court interpreted the phrase public use according to its original public meaning in the Michigan Constitution and concluded that it had a narrower meaning than the U.S. Supreme Court would find in its federal counterpart the next year in Kelo. But I am just not sure how often a similar pattern will obtain. So, what if you don't buy the premise of the argument I have just outlined? What if you think that judges ought not limit themselves to the traditional tools of constitutional interpretation, but instead should seek to infuse the Constitution with contemporary meaning? That is a viewpoint popular among judges, law students, and members of the Academy. But even here, that view largely rests on two pillars. And those two pillars may not always, or even often, be found in state constitutions as opposed to the federal constitutional system. So the first of these pillars is that constitutions are old. And the second is that they are nearly impossible to amend. Well, as to the first, yes, some state constitutions are old. As I mentioned previously, the federal Constitution borrowed most of the Bill of Rights from rights protected in the constitutions of the states that predated it. And a few of those state constitutions still govern their citizens today. Massachusetts ratified its state constitution in 1780, and it still governs. Indeed, scholars have claimed that that document is the oldest functioning written constitution still in effect anywhere in the world today. But of course, that is not the condition of all of our states. Both Alaska and Hawaii came into the Union only in 1959, and Hawaii governs under a constitution adopted in convention even more recently, in 1978. Other states, too, have adopted new constitutions in conventions of recent vintage. Michigan, for example, although granted statehood in 1837, has remade its constitution on several occasions, most recently in 1963. Georgia's constitution of 1982 is one of the nation's youngest constitutions, although Georgia itself was one of the original 13 colonies and the fourth state admitted to the Union. While by no means exhaustive, these few examples illustrate that at least some state constitutions are both younger and easier to amend than their federal counterpart, whether by constitutional convention or other means. Indeed, in nearly half the states, including Michigan and Ohio, the people themselves can play a direct role in amending their state constitutions through the initiative process. This means that if the citizens of a state are unhappy with the rights or protections provided for by their state constitutions, they have a direct means to change it. You are probably familiar and either happy or unhappy with many significant measures that have recently been added to Ohio's Constitution through its initiative process, including provisions regarding minimum wages, crime victims' rights, and redistricting. My state, too, has used this form of direct democracy to amend its constitution in significant ways. And I'm not here, of course, to take a position on these initiatives one way or another, or even to comment on the merits of direct democracy as a form of constitutional amendment. I do note, however, that when one is thinking about how judges should interpret a state constitution, one needs to consider the whole landscape. Even if one adheres to the so-called living constitution school of thought when it comes to interpreting the federal constitution, we should think hard about whether that approach is well suited to the interpretation of state constitutions, which on the whole are younger and much more amenable to democratic change. So switching topics a bit, I thought I would wrap up with some thoughts about how my time serving as a state court judge has influenced my thinking about my current role as a federal judge. It probably comes as no surprise that my state court experience comes into play most often when we are exercising what is called supplemental or diversity jurisdiction and applying state law in federal court. Working on a state court has given me great respect for each individual's state laws. And when applying state law under supplemental or diversity jurisdiction, it is crucial for a federal judge to be careful not to step on the toes of another sovereign. There are a few ways that a federal judge can exercise caution when reviewing state law. The first is just to try to get a handle on what the nuances of state law are. I think sometimes there's a tendency in the legal profession to think of the common law as a monolith. That's more or less how we teach it in law schools. Your torts book, for example, probably included a collection of cases on discrete topics, say, for example, proximate cause or premises liability, that were pulled from a variety of jurisdictions. They were chosen by the casebook editor or your professor because they illustrated a concept, and maybe because the facts were memorable. But in most law schools these days, you would not likely have been taught the tort law of Ohio, or Michigan, or Tennessee. Instead, you learned basic ideas about tort law, and you probably didn't pay that much attention to where the cases came from. That's how I learned torts anyway. And that's probably the way we need to teach law in a legal climate that is mobile and increasingly national. We need to teach the broad concepts and let the practitioners learn the nuances as they settle into a locality. The trick as a federal judge who deals with the law of many states is not to forget that there likely are nuances that we need to learn. I think my experience serving on a state court has made me more sensitive in trying to understand the subtleties of various states' laws. Of course, I won't always get it right, but I do think that my experience on the state court has made me more attuned to looking for the details than I might have been without it. And this is also a good thing to remember for those of you in the audience who are litigators or would-be litigators. The lawyers who regularly practice in a state are often our best guides to the nuances of state law. So as a litigator who may practice in both state and federal court, please do not assume that the federal judges will always already be familiar with the unique aspects of the governing law in your state. Please use your expertise and your experience to educate us and help us do our jobs well. Now, sometimes state law will just be unsettled. And when federal courts encounter an unresolved area of state law, they need to be particularly careful. After all, state courts should have the primary responsibility for deciding questions of state law. There are a few solutions to this problem. The first is the certification process. The Supreme Court has encouraged certification where federal courts are faced with novel state law questions, noting that certification puts the novel state law question, quote, directly to the state's highest court, reducing the delay, cutting the cost, and increasing the assurance of an authoritative response. The Sixth Circuit has added another reason in support of certification, that it helps build cooperative judicial federalism. Certification allows the federal courts to respect the state's ability to interpret and control the laws of its own state, allowing those who sit on the state's highest court, who presumably have the best understanding of their own law, to address new legal questions first. Certification, however, is not without its own wrinkles. First of all, it slows things down. And secondly, some states are unwilling or unable to answer certified questions. There is a dispute on the Michigan Supreme Court about whether the Michigan Constitution allows judges to answer certified questions from federal courts. So, of course, federal courts must respect the state court's determinations that it is or is not able to answer certified questions. But to the extent the procedure is available, it seems to me that we should be amenable to using it in order to respect the rights and abilities of the state as its own sovereign to interpret and control the interpretation of its own laws. But certification is not always available or practical, and a federal court may have to determine on its own what a state court would do when faced with an unanswered legal question. If we have to do that, the Sixth Circuit has instructed that we must make our best prediction, even in the absence of direct state precedent, of what the state's highest court would do if it were confronted with that question. But here we need to be careful, because we want to allow state courts to be their own sovereign, and we need to remember that we are just predicting what the state court would do. We need to make sure that we are stepping into the shoes of the state Supreme Court, not stepping on the shoes of the state Supreme Court. Because if we predict incorrectly, that could lead to a situation in which there is a law of Ohio that obtains in federal court and a law of Ohio that obtains in state court. And the litigators among you know that that will lead to rampant forum shopping, at least until the matter is brought back to our attention so that we can bring our interpretation in line with the state court decision. So reviewing state law as a federal judge is inevitable, but exercising caution, whether that be by certifying the truly unsettled questions to the state's highest court or just by paying attention to the nuances of state law, federal judges can respect the rights of state courts as independent sovereigns to interpret their own laws in accordance with the constitutional design. Thank you very much for allowing me to be with you this afternoon, and I think we should have a few minutes if anyone has questions.
We have a few minutes for questions. When you're asking a question, please wait for the microphone so that those that are watching via webcast can hear the question. Also, please be sure that a question is in fact a question, so a single sentence, perhaps a few dependent clauses, ending with an upward inflection designed to elicit a response. I'll take the moderator's prerogative to ask the first question. One area you didn't mention, which is where intermediate federal appellate courts perhaps have the most direct interaction with state courts, is habeas.
Sure.
And I'm wondering if you have any thoughts on how federal courts should approach that, because those cases typically arise in the context of someone alleging the state court didn't do its job. And does that put federal courts in a difficult position? Have we not struck that balance appropriately?
Well, when federal courts sit in habeas, obviously we are reviewing the judgment of a state court, usually as to a state prisoner. We don't, when you ask whether we struck the right balance, I would say that balance has been struck by Congress, and I have little choice. So the Anti-Terrorism and Effective Death Penalty Act of, Professor Adler, fill in the year. Thank you. Really constrains what federal courts can do. We can only grant the writ of habeas corpus if we determine that the state court not only erred, but erred by misapplying, let's see, what's the phrase? Misapplying federal law as it is clearly established by the Supreme Court of the United States. And that means there must be generally a U.S. Supreme Court case directly on point that the state court ignored. What that means is we get lots and lots of petitions for the writ of habeas corpus, and we grant very few because Congress has so deemed it, and that's my job, to follow the laws passed by Congress.
Questions for Judge Larsen?
With regard to the notion that Michigan's Constitution prohibits the Michigan Supreme Court from answering a certified question, what's the reason? What's the argument for that?
Yeah, so there's actually, it's interesting, there was a dispute between our former Chief Justice Bob Young and our current Chief Justice Steve Markman. Bob Young was of the view that the Michigan Constitution didn't allow it because we aren't, the Michigan Supreme Court, when it answers a certified question, is not in fact resolving a case or controversy. But it's not a case or controversy that is before any Michigan court, right? So there is a case or controversy that is before a federal court, but not one that has been brought through the state court system. The Michigan Constitution allows advisory opinions, unlike in the federal constitutional system, but only under certain circumstances. The Constitution says the governor can ask for one, the legislature. It doesn't say federal courts. So his position was that we could not do it. Steve Markman's position, and he's the current Chief Justice, is to the contrary. He believes there is a case or controversy, and that the opinion, that the provision allowing for advisory opinions, that list is not an exclusive list, but merely illustrative. And so it seems that Michigan will be more likely now to grant them, but I don't want to predict how my former colleagues will come down.
Another question over here.
Hi, so I have a question. If Judge Sutton was here, he might point out that one of the amendments to the federal Constitution is the First Amendment, and that amendment, you incorporate it through the Due Process Clause, but like the first word in it says Congress. So
Right.
It's a little bit awkward when you have a federal court striking down a state law and saying this violates the rule that Congress shall make no law. So is the First Amendment any different than the others in your analysis?
Well, certainly not according to the United States Supreme Court, which has incorporated the First Amendment through the 14th Amendment. Now, that's a good textual argument, I suppose, against incorporation, but that ship sailed many decades ago.
I guess the question that Judge Sutton might raise is, doesn't that sort of operate as a inhibiting restraint on federal interpretation of the First Amendment in the state context, because they can't explain to the citizenry, we struck down your law because of this rule here and point to it, that federal courts might be under enforcing the First Amendment because I think 2.005% of Americans know what incorporation is. I mean, so might state courts might be more willing to actually enforce the text of the First Amendment than federal courts are?
Oh, so I think what you might be raising is something that is often called the federalism discount. And the idea behind the federalism discount is that when the U.S. Supreme Court incorporated or applied all of the protections of the Federal Bill of Rights, which as an original matter, did not apply to the states, right? So when the U.S. Supreme Court applied all those federal Bill of Rights to the states, the argument of the federalism discount is that the U.S. Supreme Court also then watered down the federal protections in order to make them apply in all the 50 states. One example I can give you is the jury trial right. So in federal court, you get a jury of 12 and they must decide unanimously. But when the U.S. Supreme Court incorporated the jury trial right against the states and forced the states to hold jury trials in some places where they weren't holding them, they gave what you could call a federalism discount. Okay, we're going to make you have a jury trial, but we won't make you have 12 jurors who decide unanimously. It's fine if you have 6, and depending on the composition, how many you have, you must have at least 6, and they don't have to necessarily decide unanimously. That would be an example of a federalism discount. If you ask any criminal defense attorney, is there a difference between a 6-person jury and a 12-person jury, she will surely tell you yes. And is there a difference between majority vote and unanimity? Of course, the answer again being yes. And so the argument is that when the federal government, or when the federal courts imposed jury trial, they also simultaneously watered down the guarantee.
Judge, in order to bridge the geographic gap, have you and your colleagues considered using FaceTime or Skype to get the actual chance to look each other in the eyes, even if you're geographically far removed?
Yeah, so I would love to do that. And sometimes I will say this, we do all have video conferencing equipment. And we can use the video conferencing equipment if, for example, you were ill or injured and you could not physically be present at argument. Sometimes judges are able to, you can't get on the plane to go to Cincinnati, but you can make it to your chambers and sit up. And so some judges have done video arguments. We can do it that way. I haven't tried it yet. I haven't tried FaceTiming any of my colleagues, but that might be a thing. That might be a thing that we can do. I mean, technology has made it so that we can talk to anybody at any time, and I think it's something that the federal courts should consider.
We have time for one more question. Over here. Wait for the microphone, please.
I knew the answer to this question. I was in law school because I had to know the answer. Why is Erie versus Tompkins so important?
Oh, well, it's so important because it basically does away with the idea of there being a floating federal common law. In other words, it makes sure that the federal courts are respecting state law. Of course, then we go to law schools and we teach it as if there is this floating body, it's all the same. And it's largely the same. Proximate cause is usually proximate cause, although, states have individual wrinkles about it.
Please join me again in thanking Judge Larsen for her remarks. And we will have a reception in the lower rotunda starting now. So again, thank you all.